Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about Florida non-compete law and substantial customer relationships. I've already done a number of videos, articles, and blog posts regarding Florida non-compete law and customer relationships. And if you've seen any of those, you may wonder why I am doing yet another piece regarding substantial customer relationships. The answer there is quite simple. Number one, the overwhelming majority of non-compete litigation, not only in Florida, but also throughout the country, turns on customer relationships. That's really the big ticket item that people are trying to protect. It's business, it's money, it's revenue, it's customers. So this is the big ticket item. And number two, the goal here is mastery. That's my goal. My goal is to master this particular subject matter and to be the best lawyer in the country practicing in this space today. So when the goal is mastery, there is always something new to learn. There are new cases to read. There are new tools and techniques to add to the toolkit. Then there are new points of law coming down every day, every week, every month throughout the country. That's why it's a big ticket item, customer relationships. That's what people are litigating. And two, the goal here is mastery. So without further ado, let's get into the mix. I'm going to give two different scenarios. One is going to be an example of a substantial, protectable customer relationship, and the other is going to be an example of a relationship that is not substantial and therefore not protectable. The goal here is to drive home and crystallize this distinction, which is absolutely critical. So first, as a threshold matter, it is necessary to recognize that not all customer relationships can be protected. I have been involved in literally hundreds of non-compete disputes, and in many of these disputes, the plaintiffs take the martinet stance that all of their customer relationships are protectable, and that is absolutely nonsense. Florida's non-compete statute, as with the non-compete laws in many other states, gives protection only to substantial or special customer relationships. That right there means that the vast majority of relationships are off the table. They are not going to be substantial. They are not going to be protectable. How can we flesh this out? Let's look at two specific examples, one on each side of the ledger. Let's take the first example, and this is drawn from a case that we actually litigated. I'm going to change some names, but the facts are going to remain the same. There is a large national retailer of bicycles, high-end bicycles, riding bicycles, racing bikes, etc. They have a store manager. The store manager's name is Jim. Jim works his way up to become the manager of that store. Then Jim becomes the regional manager for the bike company. We're going to call it ABC Bikes, okay? Jim works at ABC Bikes for several years. He knows who all of their big ticket customers are. And in fact, believe it or not, ABC Bikes has certain customers who come back year after year after year, and every year they buy a new racing bike, they buy a new mountain bike, they buy a trainer for their house to put their bicycle on. They spend thousands and thousands of dollars every year on bicycles. They only buy their bicycles from ABC Bikes. ABC Bikes sells them those bicycles and services those bicycles, takes good care of them. Those customers have an exclusive relationship with ABC Bikes and don't go elsewhere. Is that relationship substantial and protectable? Yes, absolutely. Why? Well, number one, you have a customer. The customer has a relationship with exactly one vendor, service provider, or company. It's not a situation where this customer goes and gets bicycles from a whole bunch of different bike stores. They have a relationship with one specific bike store. It's a long-term, ongoing relationship. That bike store has a reasonable expectation of continued patronage, continued future business, and the customer, being an individual, cannot be publicly identified. If you're a competing bike company, you're a competing bike store, say you're Miami Bikes, okay? If you're Miami Bikes, you have no way of knowing who the big ticket customers are over at ABC Bikes. But if Jim, the regional manager, jumps ship from ABC Bikes, goes to Miami Bikes, and he has brought with him some sort of confidential customer information, or if he knows just off the top of his head who these big ticket customers are, who spend tens of thousands, sometimes over the course of their lifetime, more than $100,000 on bikes, and he starts to go after these customers, does that constitute unfair competition? Yes. Yes, it does, for the reasons that I have previously laid out. It constitutes unfair competition. That is a substantial relationship, and if you are in that posture, you should be able to get an injunction almost 100% of the time. That's what the law exists for. That's a substantial relationship. Your non-compete is likely going to be enforceable, more than likely going to be enforceable. Now, for the flip side, a relationship that is not substantial and therefore not protectable. You have a company. Let's call the company Tech Guys. You have some software engineers who work for this company. These software engineers start their own company. They leave Tech Guys and they go into business and start going after Tech Guys' old clients. Well, as it turns out, these clients do not have exclusive relationships with Tech Guys and never had. In fact, they use 5 or 6 different software engineers, tech vendors at any given time. They seek out the most competitive prices, and they do not maintain an exclusive relationship. Further, the clients are well-known public companies. They all have chief technology officers. So anybody in the software engineering tech space who wanted to could go on LinkedIn, could find the chief technology officer of these clients, and could send them a pitch, try and get their foot in the door and see if they could win some of the business. Is this customer relationship protectable? No, not whatsoever. You have all the hallmarks of a customer relationship that is not substantial. There is no exclusivity. There are multiple vendors being used by the client. The client is seeking competitive pricing. People are effectively bidding against one another in terms of hourly. And the client and the relevant contact people there can be identified through publicly available means. So based on all of these factors, the relationship is going to not be considered substantial. Now, what if you mix it up a little bit and you say, let's add an additional fact to this hypothetical, which is in fact a real case that we litigated. Let's add the following fact. Let's say that Tech Guys did $500,000 of business with a particular client. And then when these employees, engineers left, started their own shop, that client left and went with them. Does the dollar amount, does the fact that it was $500,000 make it a substantial relationship? The answer there again is no. No. You go back to the bikes example from ABC Bikes and Miami Bikes. Let's say the dollar amount there at issue with the client was $10,000. Let's say it was $7,000. It doesn't matter because of the market dynamics. In the bikes example, it might be 7, it might be 10,000. And in the tech engineering space, it might be 500,000. But the dollar amount alone does not have any real bearing on making the relationship substantial. It does not work the converse, however. Let's be clear about that. If somebody does $200 worth of business with a particular company, you're going to be hard pressed to say that they are a substantial customer. So it's a point of law that works in one direction but not the other. If there's virtually no spend, then it's less likely to be substantial. But if there's any significant spend, beyond sort of a de minimis level, and there's an ongoing relationship, the customer information is private, it's not publicly accessible, the relationship's exclusive or near exclusive, and there's a reasonable expectation of continued business, then you're in substantial territory. But if you're in the territory from the Tech Guy scenario, even if it's $500,000, it does not matter because of the nature of the market and market dynamics. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. Man, I love this stuff. So if you have a non-compete question or concern, please feel free to contact my office. I'd be happy to talk. Thanks for watching and have a good day.